HOA Leadership Network. Glad you could join us today for this virtual webinar where we're going to talk about 1750, the HOA legislation that was signed into law by the governor on May the 12th. So this webinar is designed to give you some overall guidance and also a look at what you can do to get ready for the bill, which becomes in effect as a law on January 1st of 2027. There's a QR code that's on your screen. If you wanted to join our network, you can do so by scanning that, and that will take you to our HOA Leadership Network site, and you can become a member. It is free to join the HOA Leadership Network. My name again is Mark Foster, and I am a co-owner of the HOA Leadership Network. I'm moderating today. I'm joined by two of our partners and attorneys who are also sponsors of our network. Finn Jacobson and Aaron Brooksby are joining today. Finn, I'll just turn it to you for a quick introduction.
Yeah, thanks, Mark. Hi, everybody. My name is Finn Jacobson. I'm an attorney here at SJJ. Work closely with all things HOA. So happy to be talking to all of you about the legislation. And I think Mark's going to mention this, but another sort of data point for all of you homeowners and board leaders is that we're going to actually be hosting a in-person board training on this legislation. We've got our first one at our offices here in Bloomington on June 14th. It has unfortunately already sold out, but we're going to actually be doing one per month. So we'll do one in June, one in July, one in August, and one in September. So if you can't make the first one, please sign up for the others. Those dates will be going live soon.
Great. Aaron, you want to give a quick introduction?
Yeah, sure. I'm one of Finn's partners, HOA attorney. If you've been to any of the Leadership Network chapter meetings, you've probably seen me there in the last couple of years. This is what I do.
This is what you do, and you do it well. So Finn and Aaron, so great to have you today. Folks, we are going to be taking your questions, but because we have so many people on this webinar, we obviously can't do this verbally. It would just take too long. So we ask you to please use your chat function in Zoom. That will allow us to take a look at the questions that are coming in, and we'll pause occasionally through this 90-minute webinar and try to answer some questions that are coming through. So use your chat function. We will end this program promptly at 6 o'clock. And the program is being recorded. So you will be able to see this recording as we move forward. If you could please mute your line. If you are not already muted, we would very much appreciate it. Thank you so much. So this is the Minnesota HOA legislation that we are going to be talking about and what everybody needs to know before that law comes into play on January the 1st. We are going to talk a little bit about the background of 1750, the key changes, what the law now requires, trouble spots that boards need to watch for, some best practices in getting ready for January 1st, and then obviously along the way, we'll surface some of the best questions so that we can get to those. Again, housekeeping, as I mentioned, chat only. We'll field some of the best ones, so feel free to use the chat function in Zoom to write your question, and we'll take a look at those as we go. We are recording this webinar. It should be available by tomorrow for any replays. We will have these slides produced as a PDF. Those will be on our resource hub and available at our website, and we'll remind you of that when we get to the end. Now, this is general legal education, not to be construed as legal advice for your specific association. If you do want any help in applying these changes to your governing documents, we would recommend that you contact Aaron Brooksby, who is one of our guests here. You see his email on the slide, and you can certainly send a note to him. All right, so Finn, I will turn it to you for the background on 1750.
Wonderful. Thanks, Mark. As many of you know, the bill did just pass. That said, it wasn't something that came out of nowhere. There's a 2-cycle legislative session in Minnesota. So this bill actually surfaced in the 2025 session, didn't really get the momentum it needed to get out of the legislature to the governor's desk. So it was brought up again this year. The bill fundamentally modifies MKIWA, that's Minnesota Statute 515B, makes a lot of changes to MKIWA. There's one section of the law that is already in effect, and that is the definition section. But the majority of the other sections do not go into effect until January 1st of 2027. So you've got a little bit of time to get prepared, figure out what you need to do and how you need to do it. Kind of the reason for this bill, to just give the short version, is there are a lot of negative news stories about HOAs, especially recently. The Reformer and the Star Tribune and various other news sources will write these stories. I will tell you, as someone who's been involved in many of those cases, it's usually a very one-sided, skewed version of what actually occurred. That said, people complained enough to their legislators. Legislators decided to do something about it. So that's going to give you the background that you need for why the bill passed and when the bill passed. And then I think the next slide actually addresses the effective dates. As I said, the definition section already went into effect. That doesn't really change anything or have any substantial effect. The remainder of the provisions, which we're going to go through in a little more detail, go into effect January 1st. So in terms of getting ready and preparing your association, doing what you're doing here, listening to this education, is a great first step. We've got 7-ish months before we need to start making sure we comply with everything. That said, there's nothing stopping you from complying today with this, right? A lot of these things are what Aaron and I'll talk about are already best practices. So with that, we'll jump into the first sort of bucket of stuff, the first section, which is the rulemaking provisions and what the rulemaking changes do. You see the citation to the actual rule on that slide, but now it goes through, and as you as board members know, when you make rules for your association, the board can generally adopt those. The board has a meeting, the board votes on it, majority rules, you make that rule. The new law specifically says rules have to be reasonable. I would argue that that was already the state of the law, but now it's simply codified. There's also going to be some new procedures for creating rules. You need to give 21 days notice prior to the board voting to adopt the rules. And then you also need to give people the opportunity to comment. Now, how that works in practice remains to be seen. I have some ideas as to how we'll do it, whether it's, you invite emails or you let people stand up at meetings. But the short version is you have to let people express their opinion and you have to give them notice before you do it. There are some very narrow exceptions to the new provision, which is, when you have emergency situation, exigent circumstances, you have to then follow up with the proper rulemaking procedure afterwards. I can't think of many examples of when you would need that emergency rulemaking power, but there is at least that exception. So that'll be something you need to look forward to in terms of making sure you follow those steps. There will be some administrative burden, right? So you have to do that 21-day notice, then you adopt it, and then you're going to have to submit it to the homeowners before it actually goes into effect, because you can't adopt a rule and then start fining people unless they know it's a rule. So there's going to be some administrative burdens. That said, thinking it through in advance like you guys are doing now, getting educated, is a really good first step for how to address that concern and that issue.
So Finn, one pause here just from we've got one question that I think is relevant. I just want to bring it up.
Sure.
We have one of our participants who wants to know if they were a pre-1994 HOA and they are not associated with MKIWA. Does this affect them if you are not part of MKIWA currently?
Yes and no. The vast majority of what we're going to talk about today will not apply to associations that are not otherwise subject to MKIWA. So your pre-94 townhomes or your single family homes. Now, there is a narrow exception, and this is something we'll address later, but I'll give the short version here. Many pre-94 townhomes are still required to fill out resale disclosures consistent with that provision of MKIWA. That provision changed and has some new language about it. And therefore, those changes to the law will apply to those pre-94 townhomes. Now, again, without going too far down a rabbit hole, there is reference in the new resale disclosure to other provisions of MKIWA, namely a collection policy requirement and a fine policy requirement. So there's at least an argument to be made that those provisions now apply to pre-MKIWA associations because it's referenced in the resale disclosure, which does apply. That said, it's not a huge burden, in my opinion, because the associations, even if they're non-MKIWA, should probably still have a collection policy in a fining schedule. That is best practice.
Yes.
So having that makes some sense.
Got it. All right. Thanks, Finn. And just a reminder for people who are joining, we've got a few people just hopping on. We will be taking questions in the chat function. So we will not take verbal questions. Please keep your microphone muted. But if you do have a question, please put it in the chat and we will field them as they come up and try to surface some of the best ones that are coming in. Finn or Aaron, back to you on the fines and due process.
Yeah, so I'm going to talk about the fines and due process a little bit. One of the complaints we heard from the legislators when they were making this was that, the association would go fine happy and make these ludicrous fines. So to address that, they put in a cap. And the cap is, the short version, $100 per violation. Now, there's a handful of exceptions, which we helped to make sure we're part of that. One is if it's a health and safety concern, right? Someone punches a board member in the face at a meeting. Two, if it's damage to property, if someone starts smashing something, or three, if it's for financial enrichment. This is a really big one, in my opinion, because if I, for example, wanted to take my unit at an HOA and put it on Airbnb, even though that violated the documents, I'm probably making more than $100 in profit. So that can just be baked into my cost and have it a cost of doing business. So now that we've got that financial enrichment exception in there, we can increase it in those situations. You can also increase it if there is a vote of the owners at a meeting, which I'll talk about in a little bit. Doesn't make a lot of sense. That said, it's politicians being politicians, not understanding drafting error, in my opinion. There's also a way that you can actually have higher fines if you say like each day you're doing this is a subsequent violation, right? Every day that you are renting out, it's a new violation, or every day these things happen, it's a new violation. So then in addition to that, you also have a requirement that you address a fine schedule or create a fine schedule that outlines, here's some examples of things that we may have and how much we fine for them. Now, it doesn't have to be, this is the entire universe of things you can do that we can fine you for. It just has to be an exemplar list of things that could be done. Now, and again, as written on the slide, this has to be done before January 1st. Again, there is some structural ambiguity in this, which is frankly a drafting error. The statute talks about homeowners voting for higher fines at a board meeting. As many of you who are board members know, homeowners don't vote at a board meeting. Board members vote at a board meeting. Homeowners vote at a homeowner meeting. How this works in practice is anyone's guess. This is just bad legislative drafting. The practical answer is probably don't try to use this. It doesn't make a lot of sense. But that said, you're still going to be limited to these fines. Make sure you follow that. If you start assessing people fines higher than that, it could cause problems for your community. Make sure you create and draft that fine schedule. Going on to some of the due process rights that homeowners have. And a lot of these are already either best practices or were in the legislation previously, but there is a right to a hearing for any violation notice. Now, previously, this law existed and said you had to right to a hearing when there was a fine. Now it's for any violation notice, which probably is a drafting error. But again, the safe conservative way to look at this is to assume that even a courtesy notice give them a right to a hearing. They build in some deadlines for how long you have to request a hearing, which is best practice. You get 30 days to request a hearing. And again, this was probably already the state of the law, but now an owner who goes to one of these hearings can have an attorney with them if they would like. Um, if the association upholds a fine after an appeal hearing, they do have to draft a written resolution. This was already the law, but now they have to give reasons, and it has to be done within 30 days. Again, not the end of the world. It's not going to fundamentally change how your association operates. It's just another administrative burden or an administrative hurdle that your board and your management company will have to do. The attorney's fees can't be charged unless the fine is upheld, which again was already the state of the law. And frankly, in my opinion, is not a great thing, because all it means is that if there is a fine, the association is motivated now to uphold the fine, because if they've engaged their attorney, they don't want to eat those legal fees. So your violation letters, your violation templates, those should be updated and make sure they comply with the new law. There's some sort of minor changes at the edges, but for the most part, this is already either the law or best practices. With respect to the fine schedule and the remedies lists, as I said, you have to maintain a written list of the common fines. You have to include a list and a description of the remedies. So this would be something like a covenant enforcement policy. Hey, this is what happens when you violate the association's rules. These are your rights. These are the association's rights. Now, these already exist in the declaration, presumably. That said, adopting sort of a standardized covenant enforcement policy will be something that a lot of associations do to just check that box and make sure they comply. But yeah, again, consolidating all of this in terms of a fine schedule, a violation list, a covenant enforcement makes a lot of sense.
All right, let's pause here for just a second, Finn, if we could. I wanted to just catch up on a few questions. And again, to folks who are listening, you can go to the chat function and give us a question. We won't get to all of them, so we'll just surface a few. So catching up on two things here quick, Finn. Several people asked, what about if I'm part of a co-op? Do I need to worry about this new law? And then secondly, if my HOA is self-managed, does this new law apply?
So with respect to co-ops, it'll depend if you're subject to MKIWA. Many of them are. And if you are subject to MKIWA, then yes, these new rules will apply to you. And with respect to being self-managed, yes, absolutely. If you are subject to MKIWA, the fact that you're self-managed doesn't change the requirement that you comply with these new laws. The only thing that triggers, whether you need to comply with these new laws is whether you're subject to MKIWA or not.
One other question here. Given the timeline on rule changes, should HOAs prioritize updates to rules to get into compliance ahead of the January 1st deadline?
I mean, yes and no. It's always good to take a look at your rules and, give them a refresher as needed. I don't like seeing rules that are 35 years old. If you want to avoid the 21-day notice, do it before January 1st. I don't necessarily see, other than the slight administrative burden, a problem with letting people voice their concern about rules and giving them a copy of it. They're going to be bound by them. They're going to see them eventually. Playing hide the ball with rules and regulations isn't something I would almost ever advise an association to do. So if you're looking to update them, yeah, it's probably a good time. Now is as good time as any to do it. But don't do it simply so you can kind of play hide the ball with it.
Sure. All right, on to interest and late fees.
I'm going to turn this part over to Aaron.
Yeah, so I'm going to talk about the next couple of sections. Interest and late fees, we have some changes here. The new statute is capping interest at 8% per year. I honestly don't remember what it is under the current law, but 8% is a pretty standard percentage point per year for interest, and so that's just now defined under the law. The bigger change is that now they're capping late fees for assessments, late fees for special assessments. It's capped at $20 or 5% of the value of the assessment. Ignore that next bullet point, because when I drafted this, I was thinking of it backwards. But essentially, the 5% is really going to apply when you have a really high assessments, really high monthly dues, or a special assessment. But most of the time, you're probably going to be looking at about a $20 late fee. I don't think this is that bad because, frankly, I mean, $20 is low, but it's not the $15 that the legislature started out with. And I think most associations that I work with have between a $25 and a $40 late fee. Some of them have a $50. And so that does, if you're up at 50, it's going to get cut in half to 20. But it might just mean that maybe you need to leverage the interest in addition to late fees, which again, it's more of an administrative burden to work out the interest, but that might be your remedy if you really want to pressure these delinquent homeowners. Let's go ahead and move on to the next one here. Again, just some trouble spots. This is just administrative, really. The late fee exposure is the legislature didn't like people or associations as bad actors throwing on massive late fees, and they wanted to cap it. The legislature were the ones that decided that $20 was the right amount. Whether or not you agree with that, that's the law now. And so that's the biggest takeaway here is we're capping it at $20 essentially in most cases. Next, I want to talk about collections.
And Aaron, sorry, I want to just pause you 1 second just to catch up on some questions here we're getting. One great one we heard is if there is a board motion relative to a fine from a resident and it's in the meeting minutes, is that appropriate for all owners to view?
Typically I say no. Most of my clients, they have kind of their general board of directors meeting minutes, and then they have what's called a closed session or an executive session or something of that nature. And they have kind of separate minutes for that. The law currently, and as it will change in January, it allows a board to close a meeting when you're dealing with potential litigation or disputes. If you're fining somebody, that, in my opinion, could become potential litigation because if they disagree, they might sue the association. So I think that falls within that category of what you're allowed to close a meeting for. The current law and the future changes also allow the board to prohibit giving out records related to those potential litigation or active litigations. And so in my mind, if you have a board meeting, an executive session where you take executive session minutes and you have a meeting minute that talks about a fine that's going to be assessed to a homeowner, I would consider that well within the protected status of a record related to potential litigation that the board is not required to provide to its homeowners. That said, I think it's best practice to not include that type of thing in your regular minutes that you send out to your homeowners. I don't necessarily think it's illegal to do that. And Finn, you might have a thought on that, but I don't think it's best practice, and I would recommend my clients not to do that.
I agree completely with you, Aaron.
Yeah.
Okay, good. Well, let's and again use the chat function. We won't be able to get to all the questions. We have a lot. We're getting a lot of questions. We'll do our best to try to surface some of the relevant ones and the best ones. So thank you for your patience. Let's go on to collections.
Yeah. So this section it changes. I created 3 different slides for this because it essentially changes 3 things that again are more administrative burdens than anything else. This first one, an association can no longer refuse payment of any kind or of any amount. I know some associations, collections policies say you have to pay in full. We don't accept partial payments. And that was a policy decision that wasn't illegal. Now, if you have that policy and you enforce that policy, now it will be illegal starting January 1st. You have to accept partial payments from your homeowners. They have to be able to pay. You can't stop them from doing that. That's really what this change is all about, which again, I don't see that as a major administrative burden. The one caveat to that, I guess, Mark, you jumped ahead. The one caveat to that is this doesn't apply if the association has already begun foreclosure. That's the only caveat. If you've already started foreclosure, and you'll have to talk to your attorney to figure out when that actually happens, But if you've initiated foreclosure, then you can require payment in full or not accept partial payments for specific reasons. Again, that's one of those situations you should talk to your attorney to figure out, are we accepting partial payments right now? But until you initiate foreclosure, you have to accept anything that a homeowner pays. The next one here, it talks about the order of payment. Again, in the collections world, I think it was pretty standard practice for pretty much all associations to, not maybe all, but the majority of associations I work with would go based on time. So if you made a payment, even if your payment said, I'm paying June 1st dues, but you had an outstanding balance of $200 in late fees and fines from 6 months ago, that payment, even if I wanted to make it pay next month's assessments, it would go to the oldest payment. That was pretty standard. And so that's what most associations functioned as. And that would essentially just whatever is oldest, that gets paid. Here, the legislature said, no, we want associations to be forced to credit payments to past due assessments prior to them applying to fines, late fees, attorney's fees, or anything else. That's a big change. But again, that's the way it's going to work now. Essentially, this means that there used to be some kind of structured ways that we could get around foreclosure to foreclose on fines and things like that. Now the legislature outlawed that by making this change, and now you have to apply payments first to past due assessments. And so theoretically, a homeowner could sit with unpaid late fees for a really long time that they just never get paid because they're only paying the minimum monthly dues. There is a minor exception here that fines that are more than 120 days old and that involve either a health and safety violation, a property damage violation, or that financial enrichment that Finn talked about just a minute ago. If it's one of those fines and it's more than 120 days old, then you can apply those payments towards those, or you can foreclose on those. Essentially, I think that's going to be a somewhat rare circumstance, but it is a carve out that the legislature kind of gave up. The next thing I want to talk about is payment plans. The law now requires that an association's board must consider offering a reasonable payment plan. They don't define any of that. And so what a reasonable payment plan is, I don't know. I mean, industry standard, 6 months to 12 months is usually considered pretty reasonable. But if you're in a situation where we have to pay the vendor and we're waiting for your $2,000 to pay the vendor, otherwise the vendor's going to sue us, I don't know if a 6-month payment plan is reasonable in that situation. And so gray area, but the thing to remember is you have to consider offering a payment plan. And probably the way to protect yourself as a board is to make a habit of putting it in writing, putting it in board meeting minutes or an executive session minutes to say, we considered a payment plan and it was rejected or it was approved or the homeowner refused our suggested payment plan or something like that. The second point on here is foreclosure can't be commenced unless a unit owner is at least 3 months delinquent. I would argue as an attorney who practices in the collections world that you couldn't initiate foreclosure without about 3 months going by, just because there's other federal laws that apply to debt collection that I would be hard pressed ever to be able to force through initiating foreclosure within 3 months. So, but they have delineated that you can't do that. And so administratively, this isn't going to change much. The one thing that does change, and again, you as board members don't need to know about this, or you're not required to be doing this. Your attorney or the agency that's performing the foreclosure for you is going to be the ones that are going to handle this. In most cases, I would imagine it's an attorney. But the pre-foreclosure counseling notices that attorneys and debt collectors are required to send prior to foreclosure, we're required to send those via U.S. mail. Now the legislature is saying you also have to send it via certified mail. apparently the legislature thinks that certified mail is more likely to be received. I kind of beg to differ on that, but it's another administrative hurdle that your collection professional is going to have to take care of. It, it's not something the board needs to worry about. Um, the big thing that was canonized or statutorized here is you have to have a written collections policy. I think that's been best practice for a really long time, so that you're not treating homeowners differently because, oh, Jim's my buddy and he's my neighbor. He's past due 3 months, but he'll get it paid. Don't worry about it. Jerry on the other side of the street's a big annoying guy, and so he's past due 5 days. We're going to send him to the attorney. That's how you get sued as a board. And so it has been best practice to have a collections policy that you apply equally to everybody for a long time. Now it's the law that if you don't have one, you're going to be in trouble, essentially. The one thing that they specified with this collections policy is that it has to provide at least 3 notices to the homeowner before you refer them to a law firm or collections agency. Again, I think this is already standard practice. If you are professionally managed, there's a very good chance that your management company is already sending like a 30, 60, 90-day or some flavor of that 3 notices before they send it to the attorney. And so, again, the legislature is just raising the floor of how an association can operate from whatever it used to be, which was anything, up to the best practice. And so, again, not a huge issue, not a huge change if you've already been doing this. It's just something you need to be aware of so that you make sure that you're following it.
Sure. Aaron, just interrupting here with a couple of relevant questions to what you're discussing. One of our viewers wants to know what happens if a homeowner refuses to receive certified mail that's sent to their address on record with the management company. So you've sent certified mail, the homeowner refuses it.
Yeah, and that's something, and that's why I made the comment of apparently the legislature thinks certified mail is better than regular mail. The way the law is written, it doesn't matter if a homeowner rejects it
Right.
or if the mail carrier never delivers it, or if the mail carrier just puts a green post-it note thing on the door that says, "Hey, we missed you, even though I didn't knock. I don't actually want to do this," and you have to come to the post office to pick it up. The requirement is that the board puts it in the mailbox, or
Yep.
that whoever is sending it puts it in the mailbox. It's an administrative burden. It's a hoop you have to jump through. You have to pay the $10 or the $12 to send it.
Yep.
And if the homeowner never gets it, it doesn't matter. We
Right.
sent it.
One other question related to the written collection policy in this bill or in this law. If an HOA has a web portal or a website, either property manager or they have their own proprietary website, if the written collection policy is on that website and that website is accessible to all HOA residents, is that an acceptable form of providing the written collection policy?
Probably yes. I think best practice would be to send it in an email too, or drop it off, or have copies of it at the annual meeting that people can pick up. Make it available. It's like what Finn was talking about with rules and regs. Don't try and hide the ball here.
Right.
Everybody's going to see it eventually, but probably keeping it on that online portal, that's the right move. When you do update it, or if you're adopting a new one, make sure to send it out, either an email blast, send it out in the mail, put it in your quarterly notice, whatever. Make sure that people know about it and they can access it when they want to. That's fine.
Very good.
I'm going to turn this now over to Finn. We're going to kind of hop back and forth, and probably in the next few we might talk a little shorter.
Okay, so I'm going to talk a little bit about board governance. There's basically 2 buckets. The first one is board terms and elections. A lot of this stuff is not going to have a major fundamental change for what you guys do. Director terms cannot be 3 years in any given one term. That doesn't mean you can't serve 17 consecutive terms if you really want to. It just means that any given term can't be more than 3 years per the bylaws. You have to have staggered terms, so you're not turning over a new board every single year. So you've got a little bit of continuity, makes some sense. There are no term limits, which they talked about doing, but thankfully didn't put into effect because frankly, we've got a fair amount of associations that can't get people to serve. This one is a little bit unique in that it'll probably end up being confusing for someone at some point. But if a director vacancy is being filled by a board appointment, you now serve the remainder of the vacated term. Sometimes it's till the next annual meeting. Now the law says it's just till the end of the vacated term. Um, and governing documents that exceed these limits need to be amended, or else they'll be considered just unenforceable. In a perfect world, we'd all amend the governing documents to make them comply with this, but frankly, if you don't, it's probably not the end of the world because the law is going to trump your bylaws anyways. The biggest change that you're going to see, though, is going to be the board meetings and how those function. Um, so going forward, before you have a board meeting, you're going to need, as board members, to provide to your homeowners a copy of the agenda and a copy of all the contracts and documents that are going to be approved. Now, how you make those available is going to be up to the board. Putting them on websites is sufficient. And then before you take any action on any item, you need to allow a homeowner or their designated representative, which might be their attorney or their cousin Vinny, to speak. Now, this basically codifies what a lot of people do and a lot of associations do, which is called homeowner forum, where everyone's allowed to speak. I will tell you in practice, this is going to lead to longer meetings for every single association because you're going to have to do a homeowner forum every time, whether you want to or not, and everyone's going to have to give them the opportunity to speak. Now, that doesn't mean that it becomes a, wild, wild west free for all. What probably we will recommend and what most associations will end up doing is having the homeowner forum at the front end, setting strict time limits for how long people can talk and what they can do. And then as soon as that homeowner forum is done, everyone's been given the opportunity, you close it down, homeowners can no longer talk. Now the board makes decisions on everything. Now, that doesn't mean the board can't take into account what Aaron or Mark just said at the homeowner forum, but you have to at least give them the chance. And the board cannot impose fines for people exercising this right. There will be longer meetings as a result of this, especially my guess is in early January when this first becomes law. And frankly, you're going to see management companies start charging for it because if you're a management company and they are contracted to provide, 10 hours a year of meetings, if your meetings now are going 3, 4, 5 hours every time, they're probably going to charge you for that. And that's because they don't work for free. I don't work for free. Aaron doesn't work for free. If your homeowners are causing these meetings to go long, then everyone's going to have to pay those additional costs. So moving to the next slide, the board meeting owner forum. I've talked about this and touched on it. It's for board meetings, not just annual meetings. Every single thing you're going to vote on, every contract, every document, budgets need to be in there, are going to give the ability of homeowners to talk. Now, probably best practice is going to be establishing policies and procedures for how you run meetings, when you allow people to talk, how you provide those documentations. I could see this also leading to a lot of homeowners turning to having more and more Zoom meetings because it's easier to control people in terms of muting them and unmuting them. But yeah, this is going to create some pretty big issues. I think this is probably from a board member perspective, the thing that will change the most. Your board meetings are going to be a little bit different here.
So Finn, let's catch up on just a couple of quick questions. So can we put a time limit on for people to speak? So if we give 10 minutes up front and we run out of that 10 minutes, we can move on, or what's your guidance on that?
I think you can put a time limit, but I don't think you can say, Aaron, you're bottom of the list, you don't get to talk. I think you can put every single person has to have a time limit. Now, what happens if you have a 600-person association and everybody wants to talk for 1 minute? That's just the way the law is written now. Sorry, guys.
Yep. One other thing related to what you covered about the terms of the board members being 3-year staggered. What if the bylaws of an HOA has all members on an annual term? They'll need to change their bylaws, I presume.
So you're talking like if it's a 4-unit association and all 4 people are on the board?
I think the question we got here is if the bylaws are, it says that all members must turn over every year.
Oh, yes. So then, yes, they probably should in a perfect world amend their bylaws, but the reality is the state statute's going to trump and override the bylaws.
Okay.
So
Right.
that the state statute is going to prevail in
Got
that
it.
situation.
Got it. And again, just
There,
so, yeah, go ahead. Sorry.
no, I was going to jump to the next slide about working
Sure.
session.
Sure. I was just going to make a quick reminder to those listening. We are using the chat function, so please feel free to put your questions in as we go, and we are surfacing some of the most relevant ones as we continue.
Now, one thing that they did, which I think is going to have the opposite effect of what they intended, is the legislature codified working sessions. Prior to this, the advice I typically gave, and I'm sure Aaron typically gave, is don't do working sessions. Working sessions are when the board gets together and doesn't tell anyone and basically makes the decisions without formally voting on them, and then shows up to a meeting and says, we're going to vote on A, we're going to vote on B, we're going to vote on C. Now the legislature says, yes, you can have this. You can have informal sessions. It requires no meeting notice. It requires no meeting minutes, as long as you're not taking a formal vote. Now, in practice, this is probably not the worst thing. I think from a transparency standpoint, I don't like it. I do want boards to have those conversations in front of the owners. If the owners want to spend their Tuesday evening listening to us spend an hour and a half talking about landscaping contracts, they can do so. They've talked at their front end, and now we're just going to do the business of, the hard job of governing, watching the sausage get made. If people want to do that, I see no problem. But there's absolutely a universe now where we're going to see more and more boards who don't want to deal with these homeowner forums and people, being upset at this, that, or the other thing. So they do everything in a working session where homeowners aren't going to be. And all of a sudden now you're going to end up where you have the board meetings are simply rubber stamping decisions that have been made in all but in all but the practical sense, in that we haven't had the corporate formalities of doing it. I still don't recommend doing these, but that's just my 2 cents. Any questions on that before we jump to the conflicts of interest and competitive bidding stuff?
Yeah, let me just check to see if there are other questions related to this. We are getting a lot of questions. We appreciate your questions coming through. We're trying to surface some of the best ones. One here, what if contracts are voted on in a meeting separate from the open board meeting? Are boards required to vote on all contracts at open board meetings going forward?
So probably not. The status of the law is that if the association can take action, the association's board can take action in one of two ways, either at a board meeting or via what's called a remote communication, which is for all intents and purposes emails. For the majority of associations, if you're going to do an email vote on something like that, it has to be unanimous, as in all 5 board members need to affirmatively say, yes, Finn, I agree, we're going to hire your firm. And if all 5 do that, then you're good to go, and you don't need to have a board meeting to decide it. Now, again, this is something that I, recommend not be used as a matter of course and as a standard procedure. This is something that should be used, when you don't have time or something important is coming up. Again, I prefer being as transparent as possible with the community and your members as to how you govern and function within your association.
Another question came in. If there are homeowners on a board meeting who are opining, they're providing a comment or asking questions, does the board need to note those specific questions in the board minutes or summarize them in any way?
In my opinion, no. The only thing that meeting minutes, in my opinion, should include are, we had a meeting, this is what we voted on, and this is what the vote was. That's it. It's a corporate record of what occurred.
Sure, and it would be acceptable to say we had open forum and we had 5 people speak, right?
Sure.
You could log that in your minutes, but you don't have
100%.
to get specific about what was said, what was discussed if it is in an open forum.
No,
Right.
not at all.
Very good. And let's see if I could just take one more here. Can votes be taken over email? We have smaller matters that need board approval between meetings. Interesting question. Can the board vote via email?
Yes, but almost certainly, unless your articles and bylaws have been updated recently, it will require a vote to be unanimous.
Yes. Right. So you can't have 3 out of 5. You got to have everybody on email saying yes to whatever's being voted on.
Precisely.
And I would think it's good best practice, Finn, then even if they do that, I know in our association where I'm on the board, if we vote that way where it needs to be unanimous, at the next board meeting, we'll memorialize it.
Exactly.
Right.
This is sometimes called the consent
Or
agenda.
consent. Yep.
Exactly.
Exactly. Great. All right. Ready to move on?
Yes. So the next one, conflicts of interest in competitive bidding. I'll just brush on this stuff quickly. It is already best practice, most of what's happened. Board members now, if they have a financial interest or their family member has a financial interest, have to recuse themselves from voting. Meaning if I was on a board and we were deciding to hire my law firm, I couldn't vote on that because obviously I have a financial interest in that. Board members can't accept payment for approval of a construction project. That's just common sense, right? You don't want to go with Joe the builder because he gave you an envelope full of cash. The same prohibition applies to community managers that are entering contracts on behalf of the association. Again, this is all good stuff that is best practice anyways. And then if you do have these conflicts, you do need to disclose them and say, hey, Finn's not voting on this because we're voting on hiring his law firm for our association to update his governing documents. So you need to like have written record of that disclosure and include it in the meeting minutes. The bigger piece of this is going to be the 3-bid requirement. So there's a lot of exceptions, and this was a very heated part of the legislation. If the association is doing construction, maintenance, repair, that is $50,000 or more. So it's really if you're doing a big window project, a roof project, a siding project, big stuff like that. And it's more than $50,000. You are required to try to get 3 written competitive bids. You have to disclose it if there's an affiliation with a board member, a community manager, et cetera. And then once you have those 3 bids, you have to select it based on a reasonable criteria. Doesn't mean you select the cheapest one. You might select the most expensive one, and that's fine. You have to then maintain records of that bid process of those 3 bids and hold those records for 3 years. Now, that's a lot of requirements, but there's about, I think, literally 9 exceptions to this. If it's an emergency and you have to do it, if you can't get 3 bids, if there's only one person who provides this type of work, if the materials are over 50K, but the labor is all volunteer. If it's warranty work, one of the exceptions we were hoping to get in there that didn't come to fruition is insurance work, because the reality is when you do insurance work, I'm contractor A, I will do the work outlined by the insurance company for amount they pay. Mark is contractor B, he provides the same scope and cost. Aaron is C, same scope and cost. Probably this means the associations on insurance claims will now be required to go out and get 3 bids for construction work that is insurance related, and those 3 bids will all be identical, which is congratulations, you've made us go do a bunch of other work. The sort of long-term problems I see with this is that might mean the days of free bids from contractors going away. So now you're required to go get 3 bids and you're going to be charged $5,000 to get the bid. Sorry, talk to your legislators.
Right. This one of the things that I think happened because of the efforts, like the hours you put in, and Aaron, and those of us who testified, and others who really worked on legislators. I think this is one where our efforts to lobby for these exceptions did play out well.
Yeah, I think a lot of the exceptions we were hoping for. I mean, this version of the bill is way better than the original version. It's still not great. There's still some problems. This is going to cost every association money. They're going to have a lot of administrative hurdles. It's kind of the buzzword you've heard today from what we've said, but there's going to be a lot of administrative burdensome things that all associations and boards need to do, which vendors like our firm or management companies are going to charge for because
Right.
we don't work for free.
One, yep. One thing that this there is some confusion around this, and we're getting a few questions related to this. So let's take this right now. This part of the bill of this part of the law does not change anything with regard to the board making the decision. So if there is a three bid review on a project that's $50,000 or more, that doesn't need to go out to all the residents for a vote. It's still within the board's purview, if they've got that authority per their rules and regs to make the decision.
Correct. And it only applies if it's a construction project of more than 50,000.
Right.
The homeowners will get to see those three bids and they get to comment on them. But at the end of the day, the decision is still going to lie with the board. And so the board could go with whomever they think is the best person for that construction project.
Sure. Now here's one for you. How and this is sort of overlapping everything. Let's ask it now though, because I've seen a few questions in chat related to this. How in the world is the state going to ensure that HOAs are in compliance? Are the HOA police going to show up?
No, there is no HOA police. There is no attorney general authority to come and, wave their magic wand. But what this is going to do is this is going to allow, if boards are not following the law, homeowners would presumably have the right to sue the association and say, you're not complying with the law. We want you to comply with the law. So the person who's going to enforce this is going to be your homeowners. So if you do not comply with this, your homeowners arguably might have a case to bring against the association.
Would this also include legal fees? So, for example, if this were related to some sort of an accident, some sort of injury or damage, where a lawyer like you is involved, and it's a $40,000 project, and then there's $10,000 in legal fees or 11,000, and it puts us at 51,000. Do legal fees apply to the cap or the
No,
minimum?
it's just for the $50,000 for maintenance, construction, and repair work,
Very
period.
good. Great. All right, let's move on from here.
I'll jump in and handle the next bit on management contracts. This one's pretty straightforward. One of the things that the legislators heard about was, we've been stuck in this management contract for 18 years and we can never get out. I've never actually seen that. It's in my mind a non-issue, but whatever. The law doesn't, I think, does some positive things. Breaks it down into three types of management contract. Declarant controlled management contracts. So that's when you're still under development. The builder enters into a contract. Those now automatically terminate 12 months after the declarant control period. Then for contracts that are entered into by a homeowner board of directors, you've got two kinds. You've got auto renewing and non-auto renewing. For non-auto renewing contracts, an association has a 30-day out, or sorry, a 3-month out, a 90-day out at any time. If I am being managed, I'm Platypus Meadows by Aaron Brooksby's management company, and I'm in a non-auto renewing contract that is 50 years long, I can put in my 3-month notice today, and Aaron has to let me out in 3 months. Now, for auto renewing contract, the association can decline the renewal as long as they provide notice 3 months before the auto renew date. This one I really like because there were other associations that I would see where they would be locked into an auto renewing contract and they could only decline renewal like 90 to 97 days before the automatic renewal. And they had to do it, via certified mail. And if they didn't check those boxes precisely, you're locked in for another term. Now it's as long as you give us at least 3 months notice for the auto renew, you can be out at the end of that term. And I'm going to turn this and some of the rest of the stuff over to Aaron.
Yeah, so grievance rights. This is a completely new thing. It's a completely new section that the legislature added to MKIWA. Let's go ahead and look at what it does. Now, this has very particular language, I'll say. A board must permit any owner to present a grievance orally or in writing on any matter other than a pending fine or an architectural application. So anything that a homeowner thinks the board is doing wrong, they get to present to the board their grievance. The board must make a good faith effort to resolve the grievance. Again, that's going to be fact specific. I don't know what that means every time. If it's unresolved, the board then has to refer that owner to the common interest community ombudsperson, which at least still right now doesn't exist or isn't hired. The position exists, but there isn't anybody filling that position right now. But again, we have to refer the owner to that office. And so that's as simple as sending an email that says, hey, please, if you have more questions, refer to Secretary of State's website or the Commerce's website ombudsperson. And you've fulfilled your duty. The association can't charge the homeowner to listen to that presentation. But the scope of this is really broad. I mean, it's going to, the purpose of this was to force boards to listen to homeowners who are upset. And it forces boards to pay attention to their homeowners. In some extreme circumstances, I think this is probably a good thing. I can imagine a situation where there's a board of three buddies that all have their rules and they're not going to listen to what homeowners say, and we're locked in for the next 2 years on the board. So good luck. In the other extreme, I can see a situation where Aaron hates his board and hates living in an HOA, and he shouldn't live in an HOA, but I'm going to demand a grievance presentation at every single board meeting until I move out or die. uh, so it's good. That's just part of serving on the board now, right? That it's a new thing. We'll see what this looks like. Similar to homeowners being able to speak at board meetings, I imagine we'll see a huge uptick in January, and hopefully we'll see it taper off as people realize that's not the intent. To be able to berate your board members, the intent is to be able to demand a meeting. I see this often where right now there's limited situations where a board must offer a hearing to a homeowner, and usually that's tied to if the board has issued a fine. Earlier we talked about now it's not just a fine, you have to offer an appeal hearing. Now anytime you issue a violation, so even if it's a friendly reminder, you left your garbage cans out, we're not fining you, but just FYI, make sure you bring them in, you still have to offer an appeal. And so similarly with the grievance rights, I think this allows homeowners a presentation to the board. It doesn't say it has to be in person, it just says orally. So probably Zoom is probably going to be the most common situation, or some form of electronic meeting. Anyway, that's a new thing. We'll see how it turns out. And yeah.
Let me ask this, Aaron, before we move from this, a couple of questions related to it. So, does the board need to allow at a board meeting, now that homeowners can opine on any agenda item, for example, do we have to have during our board meeting a grievance section, or is this a separate process in your view?
I think the best practice is going to be to adopt some form of a grievance policy as a board as like a collections policy or something of that nature, to say, if you don't want to have it at a board meeting, you can add that in your grievance policy, that grievances will be handled outside of a board meeting at a time and place that's reasonable. Blah, blah. I mean,
Sure.
I think we can adopt that by policy. Some boards might want to have it at the board meeting. I don't know.
So can boards, in your view, require that anyone with a grievance must submit the grievance in writing? That's question number one. And question number two is, can you put a time limit on any grievance presentation that is, undertaken from a homeowner?
So I don't have a good answer for that question because the statute doesn't clarify it that much. This is word for word. Here's the statute. A board must allow a unit owner to present orally or in writing a grievance to the board or a committee appointed by the board on a matter other than a fine other than a fine or an application, an ARC application. Period. That's it. So
Yep.
uh, we'll see, I guess. I think that's a something you could try is part of your grievance policy is to submit a written explanation of your grievance, and then we'll treat it like a hearing.
Yep.
Probably the conservative approach is to say if a homeowner requests it, you probably need to provide it even if you don't know what it's going to be about.
Sure. And then one last one. This has really touched off a lot of questions from the folks who are listening here today. Is there a timeline for hearing how often the grievance must be heard by the board? So, is there like a statute of limitations? Does it need to be accommodated within, a week? What if it goes a couple months before, the board can get around to hearing this out?
The statute doesn't say. Again, the language is the board must allow a homeowner to present. And
Yep.
so if we say, well, we'll let you, but we're going to let you next year, I think a court would lean towards that being you're not allowing them.
Yeah.
If we get into a situation where it's a homeowner who wants to air their grievances once a week, and we say, no, you can do it once a month. Or I can very easily foresee situations where a homeowner makes a grievance presentation about the exact same thing every single month. And I think in that situation, it's reasonable for a board to say, hey, do you have a different grievance? Like, are you going to talk to us about something other than what you talked about last month? Because we already decided last month and we referred you to the ombudsperson and we're not talking about it anymore.
Sure.
I think that's reasonable.
Understood.
But again, the statute is not clear, and I don't
Right.
actually.
Yeah.
The only reason I know what's going on is because I listen to the legislators talk on the floor and talk about how they want homeowners to have a right to speak in front of the board.
Well, luckily they gave us a gift and said, we have a couple months to figure this out. So one last question before we move on from this, and this is a common question. If there's a grievance, does the entire board need to be present, or does there need to be a quorum? Can it be done in front of one board member? How does that work?
That's a really good question, and that's probably going to be, again, best practice is going to be flesh that out in a policy. But the statute says the board must allow the owner to present to the board or a committee appointed by the board. And so depending on your bylaws, if every committee has to have a board member representative, then at least if that's what the bylaws say, then you have to have one board member present. If your bylaws don't require a board member to serve on the committee, you can pull in 4 interested or 2 interested homeowners to be a committee for grievances and listen to the upset people in the community and then bring that back to the board.
Right.
So it doesn't have to be the board. In many cases, I presume it will be, just because in many cases you're also supposed to have an architectural review committee
Mm-hmm.
and a social committee. And in Minnesota, we see that committees often don't function and just fall back onto the board.
Mm-hmm.
And so we'll see.
We'll see. Okay. We're within about 20 minutes of ending, and we will be ending promptly at 6. So let's move on to the legal fee notice section.
Yeah, I'll try and keep these at a higher level. A lot of the next part, unless I feel like it's really important or if there's a lot of questions, maybe we can slow down, but I'll try and be a little faster through this. This one is interesting because I think the legislature might have the language they used might have kind of put a big stumbling block in front of what they intended. The statute says before referring an owner's inquiry to association counsel, so to the HOA's attorney, the association must notify the owner in advance. The way that the legislators talked about this, they made it seem like anytime before you rope in your attorney, you have to tell the homeowner that you're going to rope in the attorney and tell the homeowner how much the attorney charges and that they could be assessed back those costs. The language that they actually use, it uses this bolded term inquiry, and they don't define that. I'm not exactly sure what that means, But before you refer a homeowner's inquiry to your counsel, you have to tell that homeowner that you're going to do it and that those legal fees that you're going to have to pay to the attorney might be assessed back to that homeowner. You can't charge the homeowner a cost for sending that notice. And there's some exceptions here. If you're in litigation or if you're in pending litigation, if the homeowner's already retained their own attorney, you don't have to tell them. You can just refer it to your attorney. Or if there's some kind of an immediate need that the notice prior to would cause more harm. The interesting part is inquiry. And so I don't have a really good answer of what this means. The most conservative approach and interpretation of this is before you involve your attorney with any type of homeowner dispute or homeowner inquiry, tell that homeowner, hey, we're going to refer this to legal counsel, or we may refer this to legal counsel. And so it might be a good idea to just update your standard enforcement templates with an extra paragraph or two that says, hey, if you don't comply, we may turn this over to our attorney who charges this much money and you might have to pay their legal fees.
Mhm.
And I think that's the most conservative approach to protect the association. The next part I think is really good, resale disclosures and annual disclosures. So this was a really good, I think, a win for this legislation. One of the really good things, it requires now, all Kiowa associations have a duty to provide resale disclosures when someone is going to sell their unit. The association has to provide a list of mostly financial information related to the unit and the association. And the thing that the legislature tacked on now is you also have to notify homeowners of insurance deductible amounts. That essentially this has been best practice for a long time. If you've been, I think I've presented at HOA Leadership Network chapters about this several times. And if you went to any of them in the last month where Eric Scarns was talking about HO6 policies, this is the best practice, is to notify your homeowners often of how much the association's master insurance deductible is, and that their HO6 policy should provide sufficient coverage to cover that deductible. So now the legislature and the law has now caught up to best practice again, and now you have to include that in your resale disclosure packet. If you're managed by a professional management company, one of the larger ones, they're already doing this. And so again, not a huge change, but it's good that it's codified in the law. There's other things here that you have to provide. You have to provide that fining schedule, the collections policy. If you have a reserve study, you have to provide that now. Essentially, they just, again, they brought the requirement, the legal requirement up to best practice, because if you're following best practices and even standard practices, you're already including all of these things or most of these things in your resale disclosures. So for most of you, it's not going to change how you do this. And for most of you who are managed, it's your management company that compiles that resale disclosure anyway. So good to be aware of, not something you're going to need to personally be involved with. The next one is the annual report. This changed a little bit too. Specifically, if you're levying a loss assessment, and the unit owner is going to be personally responsible, you have to notify. Again, it's the same type of best practice that we've been trying to hammer into boards and management companies for years, that tell homeowners about loss assessment coverage and that they could be liable in 60 days for a $15,000 assessment. They should have insurance coverage to handle that. And again, we're just raising the very low non-existent bar that it used to be and that it currently is up to best practices. So if you don't comply with this, you're going to have issues. And this is a situation where if you don't comply, I could see a world where a judge, when a homeowner sues and says, well, they didn't tell me I had to do this, the association could be on the hook for a lot of money because you're going to have to waive those assessments. Not going to have to, but I could see a world where a judge rules that's what the outcome is. The rest of this doesn't change a whole lot. That's the big takeaway from this one. The next section here, it talks about architectural review. Now, if you've had your governing documents updated or even drafted, if you're in a new association, anytime, probably in the last 5 to 10 years, you probably have a somewhat fleshed out architectural review policy, either in your declaration or in your rules and regs or in a separate policy. The legislature, again, that wasn't a requirement under the law, under MKIWA. And so now the legislature said, no, now you have to have it. It was best practice. Now it's codified as you have to. The one thing they changed is what was common practice was that whenever a homeowner submitted an architectural review a request, the current practice and standard practice has been if the board doesn't respond to that within 60 days, it's automatically approved. And what the legislature did here is they said 90 days. So they made it, they kind of almost raised the bar to best in current practice. They went just a little bit below, and it gives the board 3 months instead of 2 months. Again, this codifies best practices. The decision of the board has to be, or the committee has to be in writing. You have to act within 90 days or it's deemed approved. You have to provide the standards that homeowners can expect of I'm submitting an application, and here's the things the board's going to look at. It can't just be give me a magical architectural application and it goes behind the curtain and comes back with a stamp of yes or no. I have to know as a homeowner, I get to know what you're looking at and what you're considering. And so those are the types of policies the board needs to flesh out.
Very good. All right, let me just see if there's any questions related for that. If I'm just trying, there's a lot of questions, some of them not necessarily related to this particular section. I think it's worth repeating. We are getting multiple questions about the MKIWA, whether or not a association that isn't currently covered under MKIWA, whether any of this would apply. Finn did mention that earlier, but maybe Aaron, you could just, for those who maybe joined late, this seems to be a hot button. If an HOA is pre-1994, didn't opt into MKIWA, does any of this apply?
Some parts of it will, and most of those parts are going to relate to the resale and annual report disclosure requirements, and not even the annual report, the resale disclosure requirements. Most associations, there are very few exceptions, but most associations, regardless of whether or not you're subject to MKIWA or not, the resale disclosure requirements of MKIWA apply to most associations in Minnesota. And because these resale disclosure requirements are changing, and you're going to need to provide a copy of the reserve study and a collections policy and a fining policy. And the law now says, even if you're not subject and required to have one, because a non-MKIWA association isn't subject to that section, but they are subject to the section of the resale disclosure requirement. So you're not required to have one, but you are required to provide one. So effectively, you're required to have one.
Right.
So
now,
it's a yes or no. It's a really gray area that the legislature just didn't think about when they wrote the law.
Understood. And there is some time for some interpretation of a lot of this, and hopefully becomes more clear. In the previous section, you mentioned the reserve study and how that needs to be disclosed as a part of the resale disclosure and the information that's provided to someone coming into the HOA. It's triggered a few questions regarding a reserve study. It sounds like, and we've gotten these questions at chapter meetings before, some reserve studies, might have been done in 2018. Perhaps they were done in 2016, and they're just sort of slapping on a rate of inflation, but not much else is really being updated in that reserve study. In your view, is that from a reserve study standpoint, is that good enough, or should a fresh reserve study be done every couple of years?
So first off, MKIWA does not require a professional reserve study. It requires that an association review its reserves every 3 years and consider that whether or not that reserve plan is adequate. That's essentially all the statute says.
Okay.
Many associations interpret that, and I think probably best practice is to hire a professional reserve study specialist.
Yes.
To create that. And I know I'm fairly certain still that HOA Leadership Network has a sponsor that's a reserve person.
We do.
Uh, and I think those records are great. I don't really see how a board without those specific trainings and background could perform an adequate reserve study. And I think most reserve study professionals recommend updating the reserve study every 3 years. I think the cost of the update is much less than the initial purchase price. And the statute, the requirement to provide a reserve study is only if it has been done in the last 3 years. So
Sure.
if you did a reserve study in 2018 and it hasn't actually been updated, you don't need to provide it because it's not super relevant, especially in the last, I mean, 2018 to 2026. Oh, I think most reserve people's estimates would be low in terms of how much inflation has gone up and the pricing of things. And so,
Right. So nothing really has been addressed in this new law about reserve studies. It's still a bit vague, but best practice is every couple of years, a new fresh reserve study should be done.
correct. That's the recommendations that
Right.
I abide by.
Let's go on to parking. I see a few questions about parking in the chat. Let's get to this section. We've got about 10 minutes left.
Okay, we're pretty close to the end here. Parking is one of these that this is an interesting thing. I didn't realize that this was as controversial as it was, but some of the legislators were really adamant about this. The first point in here is an association cannot regulate or prohibit parking on a public right of way. So that means if your association, let's imagine you have townhomes that are split by a public road. We have the north side and the south side of the road. The driveways come right off of the main road like a normal neighborhood, but the actual road itself is public property. The association cannot prohibit parking on that main road because it doesn't own it. Arguably, I think that's what the law was already. I don't think the association's covenants only apply to association property. Public property is not association property, and so you can't enforce legally or effectively covenants outside of the common elements and the units. So the apparently there were lots of associations trying to do this. At least that's what the legislature made it sound like, and so they prohibited it. Again, I don't think this is a change in the law. The next part that's very interesting is that an association cannot restrict parking on a driveway or an area designed for vehicles that is part of the unit or that's a limited common element, unless it would interfere with another homeowner's right to access their driveway. So lots of associations I deal with, mostly, many times it's in a single family. They have a rule that says no parking on your driveways. You have to park in your garage and you have to have your garage doors shut. I think it's a little bit ridiculous, but it's a rule and it's enforceable. This law prohibits that. You own the driveway. You're allowed to park your car on the driveway. Period. Unless it's going to interfere with somebody else. And then reasonably, yeah, we can prohibit that. That's the big takeaway here. And this relates to personal vehicles. It doesn't include work vehicle, like in commercial vehicles, and it doesn't include motorhomes or recreational vehicles. It applies to personal vehicles that wouldn't damage the driveway. Those are the two big takeaways here.
Yeah, that's going to make some people a little nervous. I know that parking comes up a lot at our chapter meetings. Let's go on
Yeah.
to retaliation. Now, this was a big issue on I think the Senate floor as they debated
Yeah.
this bill.
Yeah, and frankly, they didn't define it, and so again, this is going to be another one like the grievance section where I think it might mean this, but I don't know for sure. The law says an association may not retaliate against an owner for asserting any right under MKIWA or other law. I don't know exactly what that means. I think that was probably the law already because homeowners associations can't treat homeowners differently. You have to treat everybody the same. And so I think what we might see is homeowners trying to say the board is retaliating against me because I went and had a grievance session, and the defense is we're retaliating against you because you didn't pick up your dog waste, and that's a fine. And so you see it as retaliation, whereas we're just enforcing the governing documents. And so this one, it makes me uncomfortable because I think a lot of people are now going to grab onto this and this is retaliation. You're prohibited from doing this. And it's going to scare a lot of boards. You should be scared if you are retaliating, but much of what boards do is not retaliation. It's just enforcement. Um, that's I don't have a whole lot more to say because I don't really understand what the legislature was trying to do here.
Right. Well, and it seemed like there was confusion when it was being debated. I'm certain that what you just said is accurate. So we'll
Yeah.
work it now. This Safe at Home program also brought up some debate.
Yeah, this was a relatively late add to the statute. I think it was like within 2 or 3 weeks of everything finally being approved that this was thrown in kind of at the last minute. At least that was my impression. Minnesota has what's called the Safe at Home program. This is for individuals who are victims of domestic abuse or assault. The Minnesota Safe at Home program, essentially, you can almost think of it as a witness protection program, where the state provides an address to these individuals that are part of the program, and those individuals get to use that address instead of their actual personal address on everything. And there are some penalties if you willfully and intentionally kind of dox this individual. If you share their location with the public, that's a big no-no because these people are being targeted and they could be killed or assaulted or harassed again. And this program is to protect those individuals. What we've seen recently, I'll try and be very fast here. What we've seen recently is some associations don't know homeowners are part of Safe at Home, and the homeowner either provided it to an old management company or the board lost the information and they sent them a letter at their unit address instead of at their assigned Safe at Home address. What this is supposed to do is it's to protect those Safe at Home individuals, and so associations and management either they cannot disclose that information. It kind of shuts a loophole that associations were bound to provide association records, but they weren't allowed to provide the information. And so here, this overrules the you have to provide the records. We don't have to provide the records if an individual homeowner is part of the Safe at Home program. It'll be pretty good. A little bit more administrative burden, but management companies will be trained on it. Boards will need to be trained on it.
So the slippery slope here is if that a resident of an HOA is under this Safe at Home, they're protected, and their name and address ends up in a document in minutes or in some other document in a board packet that gets distributed. That would be a violation.
Correct.
Yes.
And so if you are aware of it, you need to take special precautions to essentially bifurcate the unit owner's name from the unit address and make sure they're
I think
separated.
it's going to be posted with the video or something like that.
All right. So thank you so much on that one, Aaron. Let's continue. We've got about 4 minutes left, so I'm not sure. I think we're coming close to the end here. I'll let you go on this one.
We are. This is the last substantive slide. Essentially, it had been a practice. Many local governments, before they would grant a developer the right to develop and give them the zoning, give them the agreements and development agreements to build an HOA or to build a development, the local government would say, well, you have to make it an HOA. Because HOAs, they're nicer and the board deals with all the enforcement and it reduces the burden on the local government. That's kind of the idea that lots of the legislatures grabbed onto. Whether or not that actually happens or not, I think that's very imaginable that it could. But what they're doing is you can't do that anymore. Local government is prohibited now from conditioning approval of permits on the formation of an HOA. And that's as simple as it is. Board members, you don't need to, even homeowners, it's not really information that you're going to act on ever, but that's part of the law now.
Okay. And I know this one had a lot of debate and a lot of discussion and was sort of snapping around separately from the bill for a little bit. So at this point, again, this one, it doesn't have a huge effect on boards itself.
Correct. This last slide, not last, but this next slide here is kind of the highlights, the trouble spots, as I put it. There's a fine cap. It can't be more than $100 per fine. There's a late fee cap. Can't be more than $20 per late fee. Owners, there will be a homeowner forum at every board meeting. Boards can have working sessions now. You probably shouldn't, but you could. These grievance rights. Homeowners have a right to be in front of the board or a committee appointed by it and talk about the things they're upset about. You cannot prohibit people from parking on public right-of-ways. And the safe at home thing, frankly, the safe at home thing, I think it's probably one of the most uncommon situations, but it has the largest repercussions. So if you have an inkling that somebody might be part of safe at home, pay attention and make sure that your association is doing what it needs, because that's the one that's going to probably catch up the most boards,
Yeah.
even though it's a very small percentage of associations that probably have safe at home individuals living there.
Right. If it happens, it could have some huge ramifications. So just a quick doing before January 1st. What can we do now to get ready, Aaron? And then we'll be wrapping up here in about 3 minutes.
Yeah. So if you are managed by a professional management company, there is a very, very, very high likelihood that your management company is going to be rolling out policies and procedures so that you and your association can comply with these updates. They're going to be rolling out new collections policies, enforcement and fining policies. They're going to update the resale disclosures, the grievance procedure. I know that these management companies are doing this because my firm is working with a handful of them, and I've heard from other ones that I'm not working with that they're doing this. And most of these policies, like a collections policy, it needs to be integrated into that specific management company's procedures. And so I think it makes the most sense to do it through your management company, not through your attorney, not in every case.
Mhm.
If you don't have a professional management company, our firm, we are working on templates right now, and we're going to be able to provide those at a flat rate to associations to help you and ensure that you're going to be compliant with this as well. But the big things to know, it's what this list is. Whether or not you're self-managed or not, you as a board member have a duty to ensure that you're going to have these 7 things updated before January 1st. The biggest one is going to be the fining and enforcement policy, violation notice template, a collections policy, rulemaking procedure, grievance procedures, the architectural request procedures, and then resale disclosure documents. Those are the big 7 things that you need to make sure you're doing. But very likely, I would imagine many of you are professionally managed, you will be hearing from your manager in the coming months. And if you're not, poke them because they're not doing their job if they haven't told you about it yet, or they're just slow.
Right. Well, and I know that property managers are working very hard to get up to speed and to provide as much guidance as possible. And, so is the HOA network. We're doing the same thing, and we will be providing a lot more information as we move forward with our chapter meetings. All right, we're going to close out. I want to just, first of all, thank Finn Jacobson and Aaron Brooksby, attorneys with SJJ Law. I will tell all of our listeners a couple of things here. This has been recorded, so as soon as we can turn this around and put it up on YouTube, watch for it on our website. It'll be sometime later this evening. These slides will be converted to a PDF and will be put up on our resource hub on our website, which is accessible to members. If you're not a member, you can join us. You can go to our website and join, scan that QR code and join. And it is free to join the HOA Leadership Network. We'll also have a link in our Sunday e-blast, but you do need to be a member of our network. Again, that's free in order to get the e-blast. So there will be multiple ways to get access to this information. We strongly recommend that you do become a member and attend our chapter meetings. We will be addressing these things for the next few months at chapter meetings of the HOA Leadership Network. So we're going to close out here. We want to be true to our word. It's 6 o'clock. So on behalf of the HOA Leadership Network, my name is Mark Foster. Thank you for joining and have a wonderful evening.